Good morning or good afternoon. This is Sarah Shanti at McGuire Woods here with my colleague Paul Keel for the HIPAA Audits and Enforcement Lessons Learned webinar. Welcome and thank you for joining. We're going to start off today by talking a little bit about the HIPAA OCR's HIPAA Phase 2 audits that were really launched back in 2016, and some preliminary results have come out since then. And then we're going to talk a little bit about some of the recent enforcement actions by OCR in 2018 versus the last couple of years. Speak a little bit about the Lab MD versus FTC case, which, although isn't exactly on point with HIPAA, is certainly impactful for those that do have to comply with HIPAA and are watching the data privacy and security recent events. And then my colleague Paul is going to go into some of the interesting state cases that correlate a little bit with HIPAA or potentially could, have dual implications under HIPAA and state law. And then some of the things just to look forward to, as everybody on this webinar is certainly aware of all of the changes and quick-moving pieces in data privacy in the U.S. and worldwide. So certainly want to address those a little bit, and then we welcome your comments and questions at the end. I think we'll have a little bit of time for that as well. So jumping in into the discussion about the HIPAA Phase 2 audits. Those were launched in 2016, the spring of 2016, and were distinguishable from the Phase 1 audits, mostly in that they included business associates. This was really the first audit protocol that came to be after some of the high-tech regulations that were very clear in including business associates in some of the direct enforcement actions under HIPAA, and certainly the audits then wanted to reflect that. And so this first slide that you're looking at just kind of shows a map of the different covered entities and business associates that were affected in the different regions. About 166 covered entities were audited. 130 of those received privacy and breach notification audits. And 63 only had security rule audits. So not every covered entity that was audited on every piece of HIPAA. They did distinguish a little bit between covered entities that they really wanted to see how they were reacting to the security rule and some of the security protocols versus the more historic data privacy pieces that everybody was a little bit more familiar with still. Notably, under 9% were health plans and only 1% were clearinghouses. So the vast majority were still covered entity providers. Business associates that were audited were 41, and then again, the map here kind of shows the breakdown, which we pulled from the OCR preliminary audit results. And one thing that's a little bit notable on this map is the number of entities that were audited in the Midwest. I'm here in Chicago, Paul's on the East Coast, but we know that the Midwest historically has had a lot of breaches and a lot of complaints, and it's not exactly sure why that is, if it's Midwesterners are a little bit more prepared or aggressive in reporting issues versus some of the other regions of the U.S., or where the providers are actually just having more violations in the Midwest. But OCR certainly took that historic knowledge and used it in the audits, and really kind of focusing a large number of the audits in the Midwest. So the preliminary findings, which came out in the fall of 2017, and we haven't really had much more updates since those preliminary findings, but the preliminary findings by OCR were pretty broad, but a couple of notable things, and I included not all of the charts, but a couple of notable charts, as you'll see. One is here. But what they did is they really used a compliance effort rating of 1 to 5. So 1, we kind of call green light, was the entity was in compliance or substantially meeting the criteria of the HIPAA standard. 3, kind of yellow light, kind of inadequate, but maybe not full on in violation. Maybe they misunderstood what was required. Maybe they had good intentions or good implementation efforts that just weren't coming to fruition. So 3 is, kind of yellow light, and then any rating of 4 to 5 was really in violation or non-compliant. 4 was negligible efforts to comply, which doesn't sound good, and 5 was just there's no evidence or even attempt to kind of try to comply with HIPAA. So really egregious there. And so in this presentation, we break down everything with really either compliance, green light, or inadequate or non-compliant, which would be kind of the yellow light, red light. We try to keep those kind of distinguishable. And some of the notable results, the first one was the timeliness of breach notification. So of those that were audited, really 22% of those audited had inadequate or non-compliant timing on breach notification. And as many of you know, breach notification under HIPAA is without unreasonable delay and no later than 60 days when to the individual, and then certainly in some cases where there's a breach over 500, you also have to alert the media and OCR on a faster basis than the annual reporting to OCR. Again, that's if it's a bigger breach than 500, you have to notify OCR immediately, more or less, as opposed to waiting for your annual reporting obligations. And so I think it's interesting because that requirement is pretty clear in that you have 60 days max. And despite that real clear deadline, we're still finding that 22% were either inadequate or non-compliant in meeting that deadline. That's interesting, and we think OCR will certainly address that in some way or become tougher in compliance in some way there, because as many of you have probably been victims of data breaches, knowing the sooner the better. You can really take action. You can watch your credit cards. You can put on, reporting notices and things like that. So failing to meet that 60-day mark is pretty significant. And the chart on that last slide was there too, so you could see the breakdown specifically. For the preliminary findings, one of the other interesting things was the content of Notice of Privacy Practices, or NPP. So that's kind of the document that at first service appointment with any provider, the patient's entitled to receive a document that really sets forth how the provider can use and restrict the patient's data. So the patient is well educated that I understand my data is going to be used for these purposes. I have these rights with regard to my records. I can restrict my data flow in certain ways, things like that. So that's been around for a long time, and one of the very basic HIPAA documents, as I'm sure many people on the phone are aware. And interestingly enough, 65% of the audited entities had either inadequate or non-compliant NPPs. So the content of the NPP was not in compliance with what's required. And HIPAA does go through all the elements of a compliant NPP. So again, this is one of those where the vast majority, despite knowing about HIPAA, are really not meeting some of the very clear requirements. The provision of notice, so the element of actually providing that NPP to the individual as required and posting it on the website if the entity has a website, a little bit better. Only 25% were inadequate or non-compliant. So that's good news. We're seeing that 75% seem to be getting the notice. Unfortunately, 65% of those notices are still inadequate or not fully in compliance. The right to access records. So the patient's right to access their records and get an accounting, which is a little bit different, but certainly an access to the copy of their records. This again was pretty significant in that 89% of the entities audited had inadequate or non-compliant policies or implementation here. So again, everyone kind of believes that they have that right to get a copy of their records, but we're seeing the vast majority are not fully compliant there. And that's something that the public certainly should be noting and understand that, that right does exist, and it's really on the providers to make sure that it's set forth in a compliant manner. And for those, who have clients who are providers, and for those providers who are on the phone, we certainly ask that this be something we address with compliance officers and administrators, because it's something pretty easy just to make sure that there's a protocol where if an individual wants a copy of their records, they get it timely. It's pretty clear under the law again. So some of those pieces are more related to the privacy and breach notification rules. Getting more into the security rule, which we know providers and covered entities are struggling with much more cumbersome, much newer. The enforcement is, kind of variable over the last few years. OCR is still getting their feet under them exactly how they enforce some of the risk assessment, risk management requirements. They found that 87% were inadequate or non-compliant with regard to the risk analysis. The risk analysis, just to remind everybody on the phone, is the at minimum annual analysis of the entire entity's ePHI, electronic PHI inventory, to assess any risks or vulnerabilities, and then of course to take action for those high risks. So that's something that has become really cumbersome and become very evolved in OCR's enforcement eyes. It used to just be, maybe a few pieces of paper that, kind of showed this is our inventory, these are the risks, this is what we're going to do next year to fix those high risks. And now it's becoming something that's much more cumbersome. A lot of times providers are relying on outside, third-party, unbiased entities to do the analysis for them because it's such an undertaking and wanting to make sure that they're not being biased or missing anything. Very technical, very detailed. And OCR is certainly finding that the vast majority, almost 90% here, are inadequate or non-compliant. And that's something that they're able to enforce very easily because they ask for that document. If it's not what they expect, it's a pretty quick violation, and they can go back 6 years and enforce on the lack or in the insufficiency of that document. Again, I added the chart right here for this one just to kind of show the breakdown. It's not funny, but it's certainly kind of eye-popping that number one, which is complete compliance for the compliance rating, has 0. So none of the audited entities got a number 1 or otherwise considered full compliance for the risk analysis, which was pretty notable. So that 0%, I think, certainly pops out in this chart. Relatedly, the security risk management component, 94% inadequate or non-compliant. The risk management usually comes out of the risk analysis. So after you do the analysis, identify all the risks that your institution may have. The risk management standard under HIPAA is really to kind of manage those risks. So understanding that you can't fix everything and certainly not everything overnight, so kind of having a plan to mitigate risk. So while phase 2 has been completed and the results, or at least these preliminary results, are in, everybody's wondering about what's next. Do we have to think about and be watching our mailboxes for the next round of audits under phase 2 or phase 3? And the good news, based off of the OCR director, Roger Severino, he gave kind of some comments earlier this year, and he kind of said, rest assured, there's going to be no more audits of entities, business associates or covered entities, that we're kind of complete with that action. We have some good data. Now we have to consider what to do with those results. He said that phase 3 is not going to be another rollout of audits, desk or on-site. It's really going to now be focused on OCR compiling the results and doing kind of an overview and understanding, where the entities are and why there's such noncompliance, what OCR can do moving forward to support future compliance or, to come down with some heavy enforcement. So the good news is that we can all take a breath, can tell our clients or tell our administrators that we don't have to be on the lookout for any more audit notices or pull our resources together to be audited by HHS. But certainly we want to continue to learn from the results and take measures that make sense for each specific entity so that they are compliant and understand that these weaknesses are being noted by OCR. So certainly any future scrutiny or enforcement will probably look at these pieces first. Under this administration, we certainly understand that this administration is pushing for a deregulated government. There's lots of regulations that we're trying to streamline across all of the government agencies, including HHS and the Office of Civil Rights. And so the OCR director identifies that too. He's very clear that we're in this deregulation environment. They don't want to make more law. They don't want to make HIPAA any more cumbersome, that they would really rather push for compliance and support compliance as opposed to enforce. That's certainly an administration-specific, I think, review. Another administration that could come down in a couple of years might have quite the opposite effect, saying, wow, there's been very little enforcement in the last couple of years. We really need to make this a priority and come in and take a 6-year look back and really push for enforcement. So even though in the moment we don't expect heavy enforcement or heavy review, we certainly know that could change pretty quickly. And so having a compliance program is still really important. The OCR director further says that, they really want to reduce undue burden on covered entities, specifically providers, which I think the industry is very aware that HIPAA has put some impractical and some really burdensome standards on covered entities, and it's been costly as well, where they would rather put that money into something related maybe towards patient care or growth. They're putting it in data privacy pieces that might be cumbersome. So OCR certainly is reflecting their understanding of that. However, they gave very few specifics about how they want to reduce that burden. They're not talking about, kind of taking HIPAA to a lower level or streamlining it. So there's very little specifics. So although the bullet points here sound great, we're not exactly sure how OCR intends to do that, other than have a comprehensive review of these findings and the regulations as they currently stand, and again, try to be more supportive, so that essentially OCR would like to put itself out of business, the director stated, as an enforcement agency, and really act more as supporting and educating, which is certainly a different role than under the last administration. Despite that, everybody's noting that the violations and the HIPAA cases and investigations are really growing. So there's continued non-compliance, and so while it makes sense that OCR wants are ready to be in compliance, we're not quite there. And those violations, I think in part to public education, those cases are really growing. So where does that kind of leave us with enforcement actions? In 2016, 2017, on this slide, I just have kind of a short reiteration of what kind of happened in those years. In 2016, there was about $25 million in OCR collections and settlements. That, of course, doesn't include the cost of investigations, monitoring, or compliance action plans, but certainly the settlement amounts were very high. In 2017, obviously they went down, which makes sense due to the administration change, just about $20 million in OCR collections. But then we look at these huge numbers of, almost 177 million records have been breached since 2009, which is when the breach notification rule came into effect. And that's really only the ones that OCR knows about. So we certainly know that number is probably much, much higher, and that covers, the vast majority of American adults. Interestingly, we see that thefts are still a huge a huge number of the percentage of over 500 breaches. Paper records, which we kind of forget about sometimes, are still at about 21% of those large breaches. And hacking, we see it's almost at 20% of security incidents. All of those things are really notable, and understand that a lot of thefts can be prevented by certain security controls, or certainly by encrypting the information so that it can't be obtained. Paper records certainly require kind of their own security safeguards. However, paper records are not governed by the security rule piece of HIPAA, only the privacy and breach notification rule. So when you're doing that risk analysis under the security rule, that actually only addresses ePHI, not paper records. Then in 2018, we've seen significantly, I can't believe we're almost into August already, so well over half of the year has gone by, and we're seeing significantly smaller number of cases, really only a number that we can count on one hand of significant settlements. One of them had to do with a kind of a systemic issue where OCR had received breach notification reports on several occasions from the same entity, and finally took action saying, look, it wasn't a one-off, this is kind of happening over and over. They really put their foot down and came out with a $3.5 million fine on systematic noncompliance for an entity that certainly had a lot of financial resources to correct itself and just hadn't gone that full distance quite yet in OCR's eyes. So that's really notable to show that OCR does kind of put two and two together. So if they're seeing repeated violations, they now have essentially a hub where it used to be where each of the OCR offices kind of manage their region a little bit independently, but now they've really come to have some sort of hub so that one entity, one office out in DC is really monitoring and intaking, I believe it's actually called the Central Intake Unit, CIU, intake all of the complaints, and they kind of file them along, and even where they don't file an investigation right away, they're certainly watching where there's repeated misconduct and starting to focus on those systemic issues within entities. So something to think about, that even if OCR didn't knock on your door this year, if you've been having issue after issue, you certainly could be getting a knock in the future and a look back on all those different issues. The second case is interesting, and I think even though the dollar wasn't a big amount, it was because it went directly to the appointee, who was the receiver appointed to liquidate the assets of a company called Filefax. And really, the appointee just left some documents at a shredding facility without properly disposing, and that became a potential breach. OCR just, I think in that case, wanted to really show that your HIPAA obligations don't end just because you're dissolving, you're liquidating, you're no longer in business. HIPAA still attaches to that entity, and in this case, kind of did a cursory review and pinged them with a fine that probably felt very significant to that receiver, and understanding, that they wanted to make a point across of just because you close your doors doesn't mean your HIPAA obligations go away. And Paul and I deal with that a lot over here at McGuire Woods, where, there's a purchase or a physician's retiring and he wants to close his practice, and he's giving his records to a storage facility or something, and we really make sure that a business associate agreement is still in place, that storage facility is still going to protect those records under HIPAA. Those things are really important, but not so obvious always. The last one is something that came down very recently. MD Anderson in Texas, the cancer center there, actually appealed to the administrative law judge, which is really rare. I think this is only the second summary judgment victory by OCR at the ALJ level. Usually everybody settles. And it was for $4.3 million, which is a huge amount, one of the OCR's biggest settlements. And it's going back over 10 years to 2000. I think it started in 11, where there was a breach and it wasn't encrypted, and then there are a couple other breaches, again, more lack of encryption despite policies that otherwise said they were going to encrypt things. They just didn't fully roll it out or implement it. And again, another entity that certainly has some resources, and it wasn't a matter of, just really enforcing and implementing the policies that had been around for quite some time at that point. And so OCR, again, did an investigation of different incidents that had been occurring at MD Anderson and essentially said, look, you had policies on this point and everything, and you still didn't kind of get to where you needed to go or internally where you even decided to go, so we're going to take action. Before I turn it over to Paul, I just wanted to kind of talk about this interesting idea of lack of enforcement under this administration and what that really means for HIPAA. HIPAA used to kind of be a data privacy leader, but now is it kind of lagging in the data privacy world? Certainly, we understand that even if OCR is not enforcing or taking a lot of enforcement action, HIPAA still is the standard when there's a lot of private right of actions, still certainly affects your PR. These big breaches still make the news. Besides the possible civil suits and state law that can be implicated, we'll talk in a second about LabMD kind of finding, where there might be a potential standard to adhere to. But really, although HIPAA enforcement might not be the leader, we're finding that a lot of entities, when they are called into these class actions, other civil suits, and any other exposure, that they're finding that if they're a HIPAA entity, HIPAA is the standard that they need to meet. And if they failed to meet that standard, there certainly could be some sort of other cause of action that will take the cake. For example, an employer might have negligent supervision if one of its employees violates HIPAA and it's a HIPAA entity. We've seen that time and time again. So, even though OCR might not be as active as we've seen in the past, or potentially could be in the future, we understand that this still could trigger civil actions, criminal penalties like identity theft. I worked on a case not too long ago where OCR was investigating, but certainly individuals were also being arrested because the PHI was being used for some sort of commercial or individual purpose, which certainly triggers identity theft laws, and those unfortunately can trigger jail time and significant penalties. Finally, we talked a little bit about the next administration, whether that's in 2 years or 6 years. We certainly know that other administrations might get much more tough on enforcement, and certainly you don't want to then be putting a compliance program into action. You want to feel that you kind of have that baseline in place already. Paul's going to talk a little bit about some of the state pieces that interplay with HIPAA and data privacy, including California has a brand new data privacy law that was just passed to be effective in the next couple of years, which is a little bit like the EU's GDPR, which really impacts corporations, and similarly kind of sets a standard for HIPAA entities, knowing that HIPAA is just the beginning for them. They're probably only going to have to do more. So having that HIPAA baseline, again, might be really useful. And then I just noted public exposure as well in PR. There's a LabCorp case right now where there's a huge hack, and it's making all the news worldwide. And again, nobody wants that publicity, even if there's not a huge OCR enforcement attached to it. And then my last slide here before I turn it over to Paul is really just talking a little bit about LabMD case, which has been in the news for over 10 years now. And a lot of you are probably familiar with it, but because it's been so long and ongoing, just a refresher on the facts. Strange facts, but not uncommon, honestly. LabMD, a cancer testing facility, had an employee who I believe was using streaming music or something at the time, which was kind of an open file site. And through that, PHI could be exposed, and a security firm trying to show off how kind of fancy they were exposed that and kind of called up LabMD and said, hey, you know what, there's a weakness in your system, maybe I'm oversimplifying this a little bit, a weakness in your system, we've exposed it, why don't you hire us, see how good we are at this. And LabMD just didn't have it. They didn't hire the security firm, and then the security firm who didn't like that at all actually did the reporting to the FTC. So although LabMD was a HIPAA entity and the HIPAA violations were certainly investigated, and I think there's still a couple that might still be open with OCR, the security firm really took that another route, and being probably a little annoyed that they didn't get the work, even though they showed off their fancy security skills, reported to the FTC. And ever since then, FTC and LabMD have really been battling it out, because FTC, who can enforce unfair and deceptive practices, came down very, very hard on LabMD, like they did with Wyndham Hotels, although Wyndham wasn't a HIPAA entity, so a little bit of different facts. And back and forth, LabMD has been saying that FTC is completely overreaching and making them do a full overhaul and really complete overhaul of their data privacy and security practices and program. So this is relevant because just last month, the U.S. Court of Appeals for the 11th Circuit vacated FTC's ability to impose on LabMD this overhaul. And really they said that the consent decree was overly broad, too vague, wasn't really defining any sort of enforcement criteria or really even effectively addressing the actual issue that started this whole thing off. It did recognize the limitations of FTC's authority, and said, like, you can't enforce FTC something just because some consumer may have been impacted. It really has to be some sort of unfair practice or deceptive practice, and so that's what FTC wasn't super clear in how they are enforcing to address unfair or deceptive practice. And really has to be based off of a legal standard, as my slide kind of goes on. They did not address the FTC's negligence theory, which FTC kind of tried to say, well, okay, even if we're not exactly in the unfair, deceptive practice zone, clearly there's some negligence here. We should be able to enforce that to protect the consumer. The judge just didn't address that, and he also didn't address the argument that HIPAA entities should be excluded from FTC scrutiny, which I think is where we kind of pull it into this presentation, that HIPAA entities are exposed at this moment to not only OCR review, Attorney General's review, but also FTC. And so right now we have to kind of think of those things where even if OCR doesn't come knocking at the door, the FTC certainly appears to still have that ability, although their standards and any sort of remediation is clearly, being kind of scrutinized at the moment. And then I guess I lied. I had one more slide after that. This is the last one before I turn it over. So just talking a little bit about the impact and looking forward from the LabMD case. And that's what I just kind of stated, that FTC can continue to review even HIPAA violations if they believe that it was a deceptive or unfair act. And so where you potentially note that you have all these privacy programs and you're taking good care of PHI, if that's not the truth, certainly FTC can step in, it looks like. But again, they'll just have to be a little bit more tailored in their scope and their review. They really need to attain some real enforcement metrics in the future, and didn't really do anything to undermine what we've all believed is that HIPAA, there's no private right of action, but certainly could still trigger, like we said, different agency or civil suits under different theories. So all in all, HIPAA is still active and alive. It's not maybe as traditionally enforced as we've seen in the past, but certainly we're seeing that HIPAA is still kind of the go-to standard and being used and bringing into lots of new different causes of action. So with that, I will turn it over to Paul, and he'll talk a little bit more about some of the interesting state law out there that also comprises of some of the HIPAA metrics.
Thank you, Sarah. Yeah, I think Sarah's already really touched on it, but as she mentioned, not a lot of HIPAA enforcement, at least considered against kind of historical levels at the federal level now under the Trump administration. And certainly appears that that probably isn't a high priority for this administration right now. Obviously could change in the future as the administration changes, but I think it's important for all entities that have HIPAA obligations, whether they're covered entities or business associates, that it's still really important to make sure that you are complying with HIPAA, making sure you do everything that you need to. And a big part of that reason is the fact that despite the lack of activity at the federal level, states do have enforcement tools available at the state level, and they are using those tools. One thing to remember is that under high-tech, state AGs kind of have their own independent HIPAA enforcement authority, separate and apart from the OCR. And the other thing to remember is that many states have their own sort of overlapping state laws or even general data privacy laws that can also be used as tools here for enforcement and can have some pretty severe penalties. And then, we'll talk about I think Sarah mentioned already, but the new California law a little bit later. But I think it's fair to say that as a general trend, kind of nationwide, state legislatures are really starting to prioritize the adoption of more stringent laws and regulations when it comes to data privacy and security generally. And that's something that we expect will continue. So with that in mind, just want to talk through a few recent state enforcement activities. So one is the case of University of Rochester Medical Center in Rochester, New York. So they had a nurse practitioner who was an employee that had accepted an offer to go work for Greater Rochester Neurology. And as part of, I guess, her transition plan, she requested and actually received, which is somewhat shocking, a list of all of the patients that she had seen during her time at URMC as, under the guises of continuity of care. So what ended up happening is, I think even before she actually started her new job at Greater Rochester Neurology, she communicated that information to her new employer, and her new employer mailed all these letters out to those patients on that list, which included PHI, patient names, addresses, diagnoses, and things like that. So they emailed all these patients and said, hey, this nurse practitioner is joining us, and you have the option to be treated by us going forward. And so that obviously caused a lot of concern among those patients, confusion getting those letters. They started making phone calls to URMC, and eventually this came to the attention of the New York Attorney General's office. And so UMRC ended up entering into a settlement agreement with the New York Attorney General's office today to pay a $15,000 penalty. They also had to agree to a compliance plan, a corrective action plan, which included things like retraining workforce, making annual certifications about retraining. And as to the nurse practitioner herself, she ended up, and this was recent, URMC settled back in 2015. She just recently, I believe back in April, agreed to a consent order, and her license is suspended for a year. I think she had an additional stayed suspension and probation, but the takeaway there is personal consequences to her were quite severe. And so I think, too, in terms of kind of an overall takeaway here, is that as an organization that has HIPAA requirements, I mean, you really have to really closely keep access to PHI restricted. And in this case, the fact that she got this list without any permission from University of Rochester Medical Center or the patients, I mean, that was easy way that could have been nipped in the bud in the first place. Another recent enforcement action in New Jersey is one that was taken against the Virtua Medical Group. And so essentially what happened here is they had a third-party vendor, business associate, that was responsible for, I think, some of their IT operations in the process of, I think, installing some updates and doing some system maintenance. Back in 2016, they actually exposed the PHI of about 1,600 and change patients publicly. So it was available for a brief time on the internet. It was picked up by indexing from various search engines. And so this vendor of Virtua, I mean, they discovered this issue. They reinstated necessary security protections, but they didn't notify Virtua. So there were a lot of allegations as investigated by the New Jersey Division of Consumer Affairs. And they alleged, among other things, there was a failure by Virtua to conduct an appropriate and thorough risk analysis of EPHI and to implement appropriate security measures, failure to appropriately train workforce members, obviously failure to promptly and timely respond to the breach, and as well as HIPAA violations, also violations of the New Jersey Consumer Fraud Act. So they ended up settling. I think they paid a total of $417,816, about $407 of which was really truly civil penalties. The rest was reimbursement for the New Jersey government investigation costs. They also had to agree to a corrective action plan, which included third-party security risk analysis and mitigating actions on an annual basis for the next 3 years. And I think the big takeaway there is this is a situation where there didn't appear to be an allegation that there was no business associate agreement or that there wasn't anything like that. It's simply a matter of Virtua had this business associate that didn't fulfill its obligations, and New Jersey's position was, they didn't do enough, and not only is it's not sufficient just to have a contract that says you're going to do this, you've got to train people, you've got to put measures in place and make sure that your subcontractors, agents, your business associates are actually doing the things that they're supposed to be doing, and Virtua is obviously punished for failing to do that. The last state-specific one, enforcement action we're going to talk about is Emblem Health, which mailed a Medicare prescription drug evidence of coverage letter to 81,000 plus policyholders, and due to a very regrettable error, the mailing label itself had each policyholder's full Social Security number. So the New York Attorney General ended up settling with them, alleging that not only did Emblem Health violate HIPAA, but also New York state laws regarding data privacy, and they ended up settling that for $575,000, as well as thorough corrective action plan, which similar to the one for the last folks. They also security risk assessments every year, updates, corrective actions, things like that, and having to certify all of that to the New York Attorney General's office. So lastly, this is just sort of an interesting case, and I think Sarah talked about a little bit about kind of the idea of private rights of action. There not being a private right of action under HIPAA, but could people have claims, and people do try to pursue claims after a breach or an unauthorized disclosure, to recover damages. And this particular case in Virginia, it's currently pending before the Virginia Supreme Court, but the facts, are pretty egregious. There was a non-clinical administrative employee, I believe she was a receptionist, that used her position to access the hospital's medical records, pulled the records and access the records of a friend of hers, romantic rival, we'll say, and disclosed a bunch of that information to her friend to use against this romantic rival, including, some really sensitive treatment information. And so there is litigation that, again, is currently pending before the Supreme Court, and I think it touches on a lot of what Sarah was talking about. They're looking at, and the issues on appeal are whether there is a private right of action under the Virginia sort of HIPAA equivalent, the Health Records Privacy Act, for both the employee, this receptionist, her wrongful disclosure and access of that PHI, but also against the employer, against Carillion Clinic, for negligently allowing this person to access and disclose that PHI, and then also sort of a separate vicarious liability sort of related claim under the theory of respondeat ad superior against the hospital for letting that employee do what she did, which she should not have done. Lastly, just wanted to briefly talk about the new California law, which was recently passed, because it is such just a dramatic change. It is by far, I think, the most broad scale encompassing data privacy and security law now in America. And it doesn't go in effect until January of 2020, but it has a lot of unprecedented things. It requires businesses to tell California residents, if they request it, what personal information they're collecting. It requires those businesses to, if requested by the consumer, delete and erase personal information. There has to be a conspicuous ability for California residents to opt out of the ability of the business to sell that person's data. And businesses are, of course, prohibited from discriminating against such a consumer who says, no, you can't sell my personal information. There's Attorney General enforcement, but I think, very notably, there is a private right of action for consumers, which is somewhat unusual in the event that there's an unauthorized breach of unredacted or non-encrypted personal information. These consumers can actually bring a lawsuit and recover damages in addition to any enforcement action that the Attorney General might take. And, as is noted in the slide here, this law currently, it does have a really expansive definition of personal information, but it doesn't actually include anything that is PHI under HIPAA or the equivalent under California's State Medical Information Act. But I think nonetheless it's really important to understand that this has just been passed and keep an eye on it, because certainly California, given how important it is and the strength of its economy and how difficult implementation can be for businesses, it's likely that businesses may have to just sort of adopt a compliant procedure, granting kind of all these sort of rights and protections to folks everywhere across the country, just as a matter of practicality and maybe operationally the only thing that's possible. And this also, I think, a lot of other state legislatures are watching this. and may take similar action. And again, also remember that there's a lot of stuff that that even a HIPAA sort of regulated or an entity that's subject to HIPAA may have a lot of information that isn't just PHI, that also could theoretically constitute personal information under the California law and any similar laws that are adopted. So with that, I think we've got 10 or so minutes left, so I think we can open it up to questions.
Thanks, Paul. And I'll just note that someone asked a wonderful question about if we had the data source about the OCR preliminary results. So hopefully everyone received the link. It was, I think, in one of the earlier footnotes, but also I resent it via the Q&A section. Are there any other questions about any of the state cases or HIPAA OCR enforcement? Okay, great. So unless anybody objects, I think we can give you back a few minutes of your day, and certainly our contact information is in this last slide, so if there's anything that you'd like to talk about offline or any other assistance or clarification we can give, please don't hesitate to contact either Paul or myself.
Yeah, thank you, everyone.